Thanks, Sandy. Okay. So welcome, everyone. We have a full agenda today, and I think we'll be able to address a lot of our substantive appellate issues. And I'd like to dive right in. We had our last meeting at the end of September. On October 6th, we sent out the agenda for this meeting and some materials about Jim's memo on fees. Krista resent those just yesterday, so hopefully you all have had a chance to review them since the 6th, and then have had a chance to review them or be reminded of them yesterday. Krista will be joining us, but as I was saying earlier, she has oral argument this morning and is going to be joining us as soon as she can get out of it. So we will just go ahead and dive right in. We did get the kind of like an annotated or a version of the agenda sent this morning. Judge Britton, I think that's yours, right? And it has the answers from the judges to the questions. That's really helpful. Thank you. This legislative review, bill review can be very tedious, and so that's why we try in the agenda to say, here are the questions we hope to take up, and to the extent people are able, when you get the agendas, if you can do what Judge Britton has done, that's helpful. It lets people kind of know where what the different perspectives are. So that's a great precedent to set. Thank you for that. That'll help us address these issues. So with that, we can dive right in to the filing fee issues. And if I can, I'd like to try to provide a little bit of an overview of this one. You have a memo, you have two memos from Jim. It talks about when fees are due, and these are the fees at the outset of the appeal. So it could be a filing fee or a trial fee. These are circuit court fees. And so there's a couple issues around them. And one is what cases require what fees. And Jim's memo points out that there's different treatment between violations and misdemeanors. So under the statute 21-285 that Jim sends out in his memo, trial and filing fees are required for violations, but not for misdemeanors. And then as Jim explains in his later memo, which is about the difficulty of determining when filing fees are required, it's not always apparent when whether a case is involves violations or misdemeanors. So we have different treatment of violations and misdemeanors, and the complication that it's not always clear whether a case should be treated as a violation or a misdemeanor. So on this fee issue, the first question on the agenda is, where are the fees paid? Jim's memos bring up the question of like which cases should have these fees, these filing and trial fees. I think primarily that this is a circuit court issue. These are the circuit court's fees, right? And so before we get to where the fees are paid, there's this question about which fees should be charged, both filing and trial, and should they be charged in both violation and misdemeanor cases? I think that this is something that we'd really welcome, since they're circuit court fees, the circuit court's thoughts on this. So Lindsay or any of our trial court administrators, do you have any initial thoughts on that? Or also want to tell us if you'd like more time to circle back?
Yeah, so usually on the fees issue, we don't weigh in on the amount of the fees, but having clarity is really helpful. So if the statute specifically says that both the trial fees and the filing fee are due and in what type of cases, I think that the points that Nass made in his memo about determining if a fee is due or not and how to determine that are questions that would be really helpful to resolve. But as far as the amount of the fee, I don't think we have a position on that.
Do you, do you think OJD may have a position on which cases should have fees and whether they should be both trial and filing? Or do you want to check with?
I can check, but usually our position is that we just don't have one on the amount of the fee. It's really just, we want it to be clear in statute. That's legislative matter as far as what the fee should be in a for a particular case. I mean, the filing fee is the standard filing fee, so making it the same as the other types of cases, the standard fee is obviously useful rather than a different fee. But as far as trial fees and the filing fee, both or one, I don't think so.
So are there any thoughts on, we have at least different treatment on trial fees. We don't require trial fee. Well, we don't require, is it right, Jim? We don't require, the law currently is not requiring filing or trial fees for misdemeanors, but it is requiring them for violations.
Correct. And that is a bit of an oddity, because Oregon law treats violation cases as criminal cases for virtually every other purpose. And the only time that violation cases are treated as civil cases is for the purpose of imposing a filing fee and a trial fee. And so I'm assuming that the legislature originally imposed those fees as revenue generating measures to help the circuit court handle appeals from justice and municipal courts. But it's odd that it was only in violation cases, but not, well, I shouldn't say that it's odd, because in a misdemeanor case initiated in circuit court, there are certainly no fees. And it's not clear to me if a violation was originally filed in circuit court. I don't think any filing fee would be imposed, and I don't think any trial fee would be charged. But for some reason, on appeal from a justice or municipal court, they are.
So one way that we could have consistent treatment and clarity could be to treat the violations like misdemeanors, which would be to eliminate filing and trial fees in the circuit court on appeal. That would be, then those types of cases would be treated the same, and it wouldn't really be an issue about whether people could tell, like Jim's memo says, could really discern whether they had a violation or a misdemeanor for purposes of these fees. But like Jim said, these are probably revenue generating fees that the circuit court might want to keep. And so
on that point, my understanding is that all the fees go to the general fund. I mean, it's not something that OJD or the court is keeping. The filing fees is a general rule. I mean, there's a few specific like tech accounts that maybe some add-ons go for too, but those are very limited. But in general, filing fees just go to the state's general fund.
I see, Heather, you have your hand up.
Yeah, thank you, Justice Duncan. One virtue of eliminating the fee altogether for violation cases, you know, Jim mentioned how they're so similar to criminal cases, but one way that they're pretty different is that folks usually, unless the case retains a lot of criminal characteristics, they usually don't have an attorney. And in my experience, a lot of individuals don't necessarily know whether it was a violation or a misdemeanor. And so that could be a point of confusion, not just for the court records, but also for the individuals filing the notice of appeal. And so that's an access to justice issue that I've noticed through my legal aid work. And then also with respect to the revenue generating issue, a lot of folks would qualify for a fee waiver, but that's another bureaucratic hurdle for having their trial at the circuit court.
Other thoughts on the group proposing treating the violations the same as the misdemeanors, which would be eliminating the fees, filing fee and trial fee that would be payable to the circuit court?
The other thing that I think is worth considering, and it would be, maybe up to the legislature to make this choice. But, part of the good that justice courts do in the system is that we eliminate the burden, or we ease the burden on the circuit court. So if you remove the trial, well, not the trial fee, because I don't think we charge that in Marion County, but if you remove the filing fee, you will have more appeals, right? And so if the point of justice courts is to have specialized courts to deal with this sort of case and let the circuit court deal with the bigger issues, you sort of lose some of that benefit if you remove that. But that's for the legislature to decide, I think.
And also, would OJD be less likely to support what we're doing here if the fee was removed, and would and as Judge Kidd is indicating, legislators may be less inclined to be supportive as well. And there's the underlying basis for that. They're twofold. Number one, I think Judge Kidd is right in terms of our courts offering an alternative to circuit court dockets, which are already well busy enough. Number one, and this would certainly lessen that impact. Number two, though, just the fact that it creates the other probably original basis was along that line on the more negative side, which is to chill. I know that the maybe somebody's right to appeal those decisions to not flog up an already busy circuit court. But I think, from a practical standpoint of making the legislation that we propose more palatable to all the folks that we need to appeal to, that keeping the filing fee in place makes sense to me. Eliminating the trial fee, which strikes me as being not uniformly or necessarily justly applied across the state. My 2 cents.
Tony Rosti here. If I may, I agree with Ms. Merrick. Access to justice is a big issue here. I've done a lot of public defense in the municipal courts. I don't know that I think if the fees for filing were eliminated for violations, well, not requiring fees for violations, I think is appropriate in misdemeanors. We didn't see a lot of our clients that appealed anyway. I don't think there'd be a lot of extra appeals just because it was a cost issue. And the clients don't tend to understand this stuff, when they're representing themselves. I think the fewer impediments, the better. And I mean, the purpose of courts, the purpose of courts is to allow citizens to access justice. I don't think, in my point of view, based on my career, is not having justice courts or municipal courts reduce the clogging of circuit courts. That's not the point. The point of courts is to let people come in and have their day in court if they're charged with something, whether it's a violation or crime. And a lot of the violations do have hallmarks of criminal conviction. So I think they're equally important. And I'm in favor of no fees on those. Thanks.
Heather, I see your hand up.
Well, just to be clear, the defendant is not failing to receive their day in court. Everybody that comes into my court gets their day in court. It's an extreme point of emphasis in my courtroom. That everybody has their say. Nobody gets to rest their case unless I ask them 3 times. If there's anything else they want to tell me, if there's any other evidence they have to present, any other witnesses they wish to call. Everybody gets that. And at the end of the case, if a defendant is convicted, they get a full and complete verbal explanation of the rights to appeal. Plus upon we provide them a form information regarding, and we give them the template to fill out if they want to appeal my court's decision. and an explanation that if they wish to seek any kind of a waiver, that they need to go to the circuit court to do so and what their timelines are to accomplish it. Everybody gets that full explanation. I think it should be the practice of all courts. I can't speak to other courts though. I can only speak to mine.
And a couple of thoughts. So first, I just wanted to clarify that in my mind, this issue isn't at all a testament to the quality of the justice that individuals are receiving in the justice court or the municipal court. I mean, you know, even it's more about, you know, what if they choose to appeal for whatever reason, maybe there's a legal issue that you know, needs to be decided by a higher court because the justice court doesn't have the authority to go against, you know, a precedent or something. You know, maybe the justice court acted completely appropriately, but it's just a case that's suited for appeal. You know, there are lots of reasons a case might need to be appealed, even when the justice court was very just and fair. Going back to the filing fee, I had a question about what we understand the purpose of it to be, because I don't think that it's probably to deter people from filing appeals. I had an assumption, and I'm just curious if others think it's correct that it would be to, you know, it's the revenue generating issue, you know, to pay for, you know, the overhead or administrative aspects of it. And so I think that if the purpose behind the fee might inform how we want to handle it too.
My thought on why it's there is that each citizen has the right to one, like a free trial, right? Which they, if they are arraigned in the justice court, they get their free trial in the justice court. And if they want to use the system, the resources of the legal system, you know, double the judge time, double the public official time, double the officer time, that there is some, you know, the system is having to redo some things for them. And so that is the reason that they would pay that filing fee. And my understanding was that would go to the circuit court, right, to cover the administration for that second trial, which that person's already received ostensibly a full and fair trial below. So that was my thought about why it exists.
I don't disagree with Judge Kidd, although I disagree with the characterization of below, because we're not, justice courts and municipal courts are not really below circuit courts. Though we have concurrent jurisdiction with circuit courts for the same reason. I think when the statement was brought about that by Ms. Merrick, that we may not have, there may be legal issues that a justice court can't resolve. The circuit court is controlled by precedent in exactly the same way as the justice court is. There is no difference. We have as much authority as the circuit court. You know, in the sense of if we were to make a decision that does not correspond with the precedent of the appellate courts in the state of Oregon, we would have to do that knowing that we're doing that. And I would certainly suggest that if a judge were to do that, they better outline the reasons as to why they've decided to not follow the established precedent. But in terms of the legal capability and capacity for that, there is no difference between a circuit court and justice court in that regard.
And I see Lindsay's hands up. Lindsay?
I just wanted to offer that I think we could probably pull the numbers on how many of these appeals we have and how much money we are getting in filing fees that the circuit court is collecting and passing on. So we could do that, and I could provide that to this group just so we have an idea what the impact would be as far as dollar amounts.
I think that would be helpful, and if you could report back on that, and if OJD has a strong opinion on whether to keep these fees or not, if we keep them, maybe they should be uniform, which would actually be adding fees to misdemeanors, or the alternative would be to eliminating them for violations and misdemeanors. But some uniformity of practice, I think, would facilitate the ease of just moving the case forward, because it's really difficult to figure out whether your appeal is going to be classified as a violation or misdemeanor. So
Justice, I mean, I also want to add one last thing, if I may, on this particular topic, because I think when we talk about misdemeanors and violations and also that we're having this conversation is like they're the same in so many ways, and there are certainly similarities. But bottom line is, you know, in a traffic violation, it's not proof beyond reasonable doubt. It's a preponderance of the evidence standard, and there's no liberty interest at stake. So there are some rather significant differences, and I would think that that's when we talk about why there's some differences and why there's some, including some important differences. That's why.
Also, the misdemeanor defendant might be in custody and not have the ability to pay a fee. That might have been taken into consideration. I know we're not talking about civil cases yet, but the civil filing fee for an appeal is $170.
So that's interesting.
And it might be interesting if Lindsay can find out if trial fees are collected by courts and how much that is. I know in my county, there's no trial fee, there's just a filing fee, even though there's a statutory provision for it, it's not collected.
This will surprise nobody, but in Washington County, there is also a trial fee on top of the statutory filing fee for a small claim appeal. So the total amount to appeal a small claim in Washington County is $309.
Paul, I see your hand again.
I think one thing to keep in mind if we're thinking about consistency is I think there's no filing fee for criminal appeals to the appellate courts, but there is a filing fee for traffic or violation appeals. And so just as we're thinking about consistency, there's two sides of that too.
So on the what types of cases should fees be imposed and whether there can be both trial and filing. I think we've had our discussion. If people want to kind of digest that, take it back to their groups, we'll hear back from Lindsay, especially about whether OJD has these are fines that are at least being collected by OJD, even if they're not being retained. So with OJD as the circuit court, we want to make sure what they think on what cases and which fees to apply. And then if anybody else has final thoughts, we can receive those in writing, like Judge Burton did on this last agenda. So people have a chance to think about that, and then we can bring this back. I don't know that we have to say this is exactly what we're going to propose, but is there any, let's move on from the filing fees, what types of fees and what cases, to the related issue of where they should be paid. These are fees that go to the circuit court, and we have a question about where the fees should be paid. My understanding is that they are currently paid to the justice or municipal court. Right, and then, but if there's a waiver or a deferral request, that is submitted to the circuit court. And so one of the questions is there anything we can do to make this process easier for people so they don't have to bounce between courts? So the circuit court has the authority to waive, statutory authority to waive and defer. I think what I'm hearing is people think that that should stay with them. Is there any way we can say, okay, well, appellant, come to the justice court and file your notice of appeal and or your fee or waiver form, and then justice or municipal court will transmit that. An alternative would be to say, file your notice and fee and or waiver or fee or waiver form in the circuit court. So I'd like to open that up for thoughts and either thoughts about what we can do to help make this process as easy for folks to navigate and administer as possible.
I don't know if it would be possible for Lindsay to get information from the circuit courts about how many notices of appeal come to the circuit courts via the justice or municipal courts versus how many are filed directly with the circuit court. Originally, I was of the view that these notices of appeal ought to be filed in the circuit court because that's the court that will have jurisdiction to hear and decide the case. But I've been influenced since then by the information about apparently most, if not all, justice and municipal courts provide form notices of appeal and instructions. Sorry, that's my law clerk there. And it certainly is handy for litigants if they're unhappy following the hearing, just to go out in the hallway to the clerk's office and fill out the paperwork and have the justice court or the municipal court ultimately transmit the paperwork to circuit court. So, but I don't know how often that happens. So I think it'd be helpful to know if the circuit courts are able to discern that. Are most notices of appeal in these cases coming to the circuit court via the justice court, or are they being, well, I take that back. They necessarily have to be, because all those notices have to be filed in the justice court. Never mind.
I think that's right. I think that there is a uniformity or consistency with the notices of appeal being filed in the justice court. I think the filing fee is different. I think we see different practices around the state on whether or not the justice court takes that fee and then passes it along to the circuit court or tells the litigant to file the fee in the circuit court. I think that there is some variety there, but I do think that the notices of appeals are being filed in the justice court.
One advantage of that is that the convicted individual is going to know their local court. That's the first place they're going to contact anyway. And the justice and municipal court have the information about the appeal deadline and what types of cases can be appealed. If someone files a notice of appeal directly with circuit court and circuit court accepts a $281 filing fee and later finds out that they filed it on the 45th day because the circuit court would have no way of knowing that in advance, would they be able to refund the filing fee? Those are some of the other complications. If it starts with the local court, they have all the information, forms, and can collect the fee and send it to the circuit court.
And if that's an easy way for the litigants to do that, and the only complicating factor is that they might want a waiver or a deferral, and they would have to go to the circuit court to get that first and then come back. Can we eliminate that step by allowing them to file their notice of appeal in the justice or municipal court with a form request for, they can either provide the money or they can provide a waiver. And I guess that's a question for the circuit court. Like, is the circuit court comfortable receiving a case when there's a waiver or deferral request? And I think that's a question for the TCAs and for the circuit court. So that would be one way to streamline it. As that would be one way to eliminate this bouncing back and forth when people want waivers. And the other way would be to just put everything in the circuit court, but that creates issues about whether people will know how to do that. So there's advantages and disadvantages to both approaches, but if there's some way we can pick one and eliminate the bouncing back, that would be great. So let's see some people popping up. Are there additional thoughts on that issue?
I think if the circuit court would be willing to do that, Justice, that would be fantastic. If they would be willing to accept an appeal, and with the notion that they don't have the fee and they haven't granted a waiver or deferral yet, but they accept the appeal, pending that would be, I guess, their ruling on a deferral or waiver. But otherwise, I think starting the process with the either municipal or justice court, in terms of an access to justice question, there's no doubt that the local court will do a better job, in my opinion, of making sure that they have what they need and have the instructions on where to go and how to proceed. So it's not that I want that work to remain in my court, but I think it's important that it does for the sake of the litigant. But I can't, but I think the circuit court has to make the decision on their filing fee.
And so maybe I see, Linda has her hand up.
Hi, I'm the court administrator here in Marion, and I think I'm the only one that made this meeting. I don't think John was available today. Speaking only for Marion, I have no problem doing what's suggested, is that the case is filed with us and then we make the decision. The only issue would be, and I'm trying to think through it in my head, and it would just be a local process. We certainly wouldn't put it on the record until we either had a signed fee deferral or an approved fee deferral. But there is certainly a way, I think, for us to make this easy on the filer and on the justice courts, where the notice comes to us with the documents from justice court and either a filled out fee deferral already or something. I think there's a way we can make that work. But until we had either the fee or a fee deferral, that case would not get entered into the record for us. So that is something that we could certainly work on here locally with our circuit courts.
Well, in fact, in fact, I didn't know I was not supposed to do this, but we actually just we allow them to fill out their fee deferral and we just send it to you. So if they request it, then it goes to you. And in fact, when I was a baby judge, I signed a couple fee deferrals a couple times that were like super clear cases. So I apologize. Although it sure made it, I think, easier for the litigant, right? So I'm all for just, that's a system that we have here. I don't sign those anymore, but we send it and then, it's filed as far as the person knows.
Right. And I don't think, Justice Kidd, that we have denied any of those. I think the fee deferrals come in, they're approved by process, and that case is entered. So I think we have a pretty good system here. And I think that would probably be the easiest if that is what you all decide.
Well, also the individual does not have to physically travel to the circuit court to get the fee waiver or deferral form. It's available online.
Correct.
I do wonder what would happen with those records if the fee waiver or deferral is denied. If the circuit court would then send that back to the justice court. So there might be a little back and forth if that occurs. And if no filing fees paid, like if the litigant's fee waiver or deferral is denied and they do not pay the filing fee owed.
Is there a small group of folks who would want to try their hand at outlining a process for just describing, a process where the appellant would file the notice and the paperwork for a fee waiver or deferral and how that would work? And Lindsay, maybe that you and some other people who want to could see, like try and outline that, and in outlining it, see if there'd be any problems, and also could get feedback from John and anyone else, other TCAs at the circuit court level to see if this would work for them.
Before I'm sorry, I interrupted.
Go ahead.
Well, as far as Lindsay's question, if the fee deferral or waiver has not been approved by the circuit court within the 30-day deadline window, or the filing fee has not been paid, then I don't think the appeal would move forward. So that's something else that would need to be decided. If the individual files on the 30th day in justice court and there's no fee or fee waiver approved yet, then what are you going to place on a deadline for that individual that'll be different from the person that just takes care of the filing fee, pays it within the, at the time that the case is filed at justice court?
Yeah, that's a very fair point. I think we'd have to, if we're going to do it that way, which is not necessarily a bad way, in my opinion, but then we're going to have some other statutory provision for a deadline on a ruling on either the payment or the approval of the waiver or deferral.
Did I have a question, and maybe Jim knows the answer to this or someone else, but if the notice itself is filed, but there's a deficiency with the payment or another deficiency, does the filing of the notice itself satisfy the timeliness requirement. And if it, and if it doesn't now, is that something that we could do to address this situation? To say, like, if you have filed your notice of appeal within the 30 days in the justice court with your payment or your waiver request within the 30 days, it's timely. And then maybe the folks who will work with Lindsay on process could address, well, what happens if in the end they don't get the deferral and they fail to pay?
So I have an idea, and I wonder what this group thinks about this idea. So could we have a rule where the presiding judge of the circuit court could like deputize the justice court judge or pro tem the justice court judge for the sole purpose of deciding fee waivers? And then that way, like that person would have that decision right then, right? It would be OGD deciding to give up a little bit of control because it's obviously their fee, but I'm just trying to problem solve in a way that makes it easy for the customer.
I'm not sure that a circuit court judge could delegate judicial duties outside of the judicial branch.
Well, like, for example, no, but we can pro tem for
Right.
downtown, right?
But
So like
muni-
I'm a pro tem for, or, you know, you can, if
Right.
it's designated.
The justice court can, I think this is Judge Brisbane's point, right?
Right, right. The justice court can pro tem for circuit court judges, but there's not a provision for municipal judges. And we're
And-
dealing with both appeals.
And there's probably a constitutional issue there because the circuit
There
court
is.
can't,
Yep. We're
Yeah.
considered, municipal judges are the executive branch per case law.
okay. So,
Just a second.
yes,
Linda, correct me if I'm wrong. My understanding is that if a person came to the counter seeking to file a new case and had a motion to waive or defer fees with it, and let's say it was the 30th day, and you couldn't rule on the motion to waive or defer fees that day, but it was granted by the judge the next day, do you record as the filing date the date that you physically received it or the date that the judge ruled on the motion?
We would, and that's rare in Marion County, and I can't speak for all circuit courts, but most circuit courts have staff that have been designated to approve fee deferrals. So I'm sure there are issues in some courts where it might take till the next morning, but for the most part, I would think that most courts are getting them done pretty quickly in the same day. But if we did have to go to a judge and if we couldn't get to a judge till the next morning, the judge approved it, we would accept it the day it was sent to us.
and
So
maybe,
it would be the 30th day.
and maybe if we're designing a process to fit this situation, we can say you file in your local court with your deferral request, as long as you're filing in your local court within the 30 days, you're fine. Then the circuit court will have whatever amount of time that they need to rule on the deferral request, and then the appellant would perhaps have a prescribed amount of time to cure any deficiency by failing to pay. If they don't get the deferral and they have to pay and they don't by X date, then the notice is not properly perfected and dismissal would be appropriate. So if there's folks want to outline a process of that, would be something that they could think about.
One other issue is when the defendant files a notice of appeal in justice court or municipal court, it takes several days for the court to get the court record prepared to send to circuit court. So there's going to be a lag of, well, right now it's 30 days, which is why the statute currently requires the person to pay the filing fee or submit the approved fee, deferral, or waiver by the 30th day in the local court.
But the reality is that the circuit court almost never will receive the notice of appeal along with the filing fee or the motion to waive or the fee within the 30-day period. The circuit court will almost always receive the paperwork after the 30-day appeal period has expired. perhaps what we could do is write into our legislation that the filing date of the appeal will relate back to the date that the notice of appeal was filed with the justice or municipal court, notwithstanding when the circuit court actually receives the notice of appeal filing fee or grants a motion to waive or defer fee.
I think it could be clearer. I think Jim, except with regard to the time for ruling on a deferral or waiver, I think essentially that the statute's written that way now. I mean, the appeal is filed currently in the justice or municipal court, and that's the 30-day, that's your deadline, is to file it in that court. And then we transfer it over to the circuit court. We don't have to get it to them by 30 days. When I first took over it, Washington County Circuit Court thought that was the case. I convinced them otherwise. Because I think really that's clearly how the statute's laid out. But I have no objection to being extra clear, because there may be some confusion that does exist out there. But I think, Justice Duncan, if I understood you correctly, essentially what you're saying for perfection, the filing will be in the justice or municipal court, the notice for the appeal, and they would have to submit either a copy of the deferral application or waiver application, or some proof that they have submitted that to the circuit court, and that would suffice. Either the payment or a document like that would suffice then for perfection to occur, and for us to transfer the case over to the circuit court. Is that what you were saying?
So I was thinking that then if we want the notice to go to the local court, the notice would go to the local court with request for a waiver or deferral, but that waiver would be the local court would get the waiver request, and the original, so that they didn't have to go to the.
We would transfer it. We would transfer it to the circuit court on behalf of the litigant.
And you would transfer it, and then the circuit court would have to rule on that. If they denied it, then there would have to be some process for the person to pay. And if they didn't do that, then the appeal would not be perfected in the circuit court. And well, actually, yeah, maybe. So those are some ideas. And we can, if there's a group of folks who want to try that process, try to write out that process, or.
I would join that group, but I wonder if Linda, if you would join me in that group.
I will. I am Lindsay and said I'd be happy to be on that group.
Great. And I see Heather's hand is up too. Heather.
I wanted to share that Jim's idea makes a lot of sense to me. What I've observed, and this is from municipal court, is that sometimes it can take a while for a file to go to circuit court. And in my experience, they've just treated it like it was filed that it was filed in the circuit court at the time it was filed in the municipal court. One other unrelated comment I wanted to share is something from a colleague in another area of the state who had the situation where a municipal court, and again, this is a municipal court, but I think there's some, it can be generalized, the issue that the municipal court thought that it could collect a filing fee, and the circuit court thought it would collect the filing fee. And so I think if there's clarity that, and maybe this will be very clear in the process when the process is outlined, but that there's only one filing fee, that would be really great, particularly for lower income clients.
Okay, so you're saying that both the local court and the circuit court were collecting the filing fee. Okay, yeah, I think we could make sure that that's clear, that shouldn't happen. And I guess we can also just remember that our immediately preceding discussion about whether you need a filing fee is what creates this bouncing back and forth, right? And so if we want the filing fee, then we have to figure out how to streamline it. If we don't have the filing fee, you just file your notice and off we go. So
just to make clear, I don't think there needs to be shifting of paperwork back and forth. Once the justice or municipal court transfers the materials to the circuit court, even if the circuit court would deny the motion to waive or defer fees and the appeal is ultimately dismissed, as I understand it, the circuit court hangs on to the paperwork, and it goes into some sort of administrative file so that the record is there and it stays there. So there's no need to send the paperwork back to the justice court. It would simply, once it gets sent over to the circuit court, it simply stays there.
Yeah, what I was talking about is it's my understanding that some of the local courts don't send the paper until they have the money or a copy of a approved waiver. So you don't even get to the circuit court until you've gone. You don't get your papers to the circuit court until you've gone to the circuit court and gotten your waiver and brought it back to the justice court.
Well, I guess we should ask Linda, does that paperwork get sent back to the litigant, or does the circuit court hang on to it?
You know, honestly, Jim, some things we do send back on an appeal. We probably would just file it in a file. But for us, it's very rare to deny a waiver or a payment plan or a filing fee. I mean, it's very rare for us to do that. So it would be, you know, 1 in 100 or 1,000. Either they're approved for the most part, or we put them on a deferred filing fee. I can't imagine that this would come up all that often in the circuit courts where it would just be a flat denial. But in this case, we would keep them from the justice court or the municipal court.
So it sounds like, are there any other thoughts on that? Otherwise, if you have volunteered or you would be willing to serve on a group that really just write out what the process would be, and taking into account like what's the effective date of the filing, that would be great. You can raise your hand now, or also just email Krista, I guess, if you would. Email Krista if you want to be part of that group to outline the process. So that's related to notice of appeal, which is our next section. So I think that process will take care of that. I think there's consensus about it would be very valuable if there was a uniform notice of appeal. So Jim has started to work on that, and we'll keep going on a uniform notice of appeal. I think it'll be especially important to have the circuit court's input on that because it's a circuit court filing.
Justice Duncan, are we going to postpone then the problem of the litigant being able to determine whether it's a misdemeanor case that does not require fees or a violation case that does?
I think we want to, right, we want to know whether we're keeping these fees at all. And Lindsay's going to report back about how many of these appeals we have, and then we'll have a sense of what would be the consequences of eliminating the fees. And if we eliminate the fees, then we don't have that problem of the different. Okay. So I think that is not a resolved issue about whether we will have the fees, which cases, and which of the fees. Heather.
Do you think that data will include information on what proportion of those cases received a fee waiver anyway, whether that information is ascertainable? Because that could also go to how much fees or revenue it generates.
Right. Because it sounds like there's a lot of fee waivers.
I can ask. I'm not sure if that's as easy to get that information, but I will check with our financial folks and see what I can get.
As we close in on the end of our hour, I want to flag some other issues that, in addition to kind of consensus that I sense around creating some sort of sample notice of appeal, I think there's, at least we have from the judges on the issue of whether or not we should include information about how to serve other parties. There's a suggestion that we include a reference to the ORCPs on service in our bills, so people at least have a pointer to the relevant law. I imagine that's probably non-controversial. So we can do that. Then the last thing that I would hope we might be able to talk about at least is for the service. One of the challenges in this area is who do you serve, because these cases can be prosecuted by different entities. Judge Britton, with me scanning my, you have in the judge's responses to the questions have a suggestion about who should be served for the different types of cases. Would you mind describing that for the group?
So depending on the type of case, if it's a justice court violation or misdemeanor appeal, you're going to serve the police officer and the district attorney. If it's an ordinance appeal, it would be the code enforcement officer and the county council. And then for municipal court violations and misdemeanors, it would be the police officer and the city attorney. Or if it's a code, it would be code enforcement officer and the city attorney.
And how does that compare to what's currently required in your understanding? That would be one question. And then my other question would be what would be the mechanism for service on the officers? I mean, I assume they would just serve, the person would just serve the officer's agency. Is that what you're thinking?
You know, I don't know if we got into that level of detail. Do one of the justice court judges want to weigh in? I mean, that's how we do it in our court.
Right, the person would serve the officer's agency. And then the district attorney obviously has an office in the county as well as county council. And I guess also in some of the ordinance appeals, code and court ordinance appeals for justice courts, possibly the DA could be involved, although I know in Washington County, it's always county council. The statute provides for either one. But you always serve the agency, even when circuit court notifies an officer of a trial date, they're going through their agency, not directly to the officer. It's a statutory requirement. I don't know the statute off the top of my head, but there's a requirement like that.
So would it be helpful if maybe in the draft we could make that explicit so that we don't have people trying to serve individual officers because they're supposed to by law be serving those officers' agencies?
I didn't know that. So I have my officers stick around because almost all my appeals are immediate. Like we know generally before the person leaves the building. And so I just have the officer stick around and they just serve them that way. But
I can find the statute for you, Judge Kidd. I'll send you.
I 100% believe you. I just didn't know.
Could the form notice of
down there?
Sorry about that. Could the form notice of appeal specify that with an address? I believe I've seen those on notices of appeal, and there'd be slightly different kinds of notices of appeal depending on the action, but the notice of appeal given by the trial court, the clerks, could specify just an address. I think the Eugene one has that, if I remember correctly.
It's a little more complicated for justice courts because we may have up to 50 agencies citing to our courts for violations.
Right.
But I'm sure the court clerk points them in the correct direction.
I think it's good practice to have a little information form to hand out. And I think, Tony, that would be good to make it clear on there. And I'm going to double check the one I hand out now to see if it is clear on there as to whether or not it says you must serve the agency of the officer who issued you the citation, and make it clear that it's spelled out in that fashion. I think that makes a lot of sense.
So that brings us close to the end of our meeting, and I think that gets us to section 11. We will circle back next time to check in on fees, what types of cases, what types of fees. And then we will hear back from our subgroup about what would be a good process for the waivers and the notice of appeal. So we'll take care of those things. I think we've resolved some other things that we have consensus on. Section 11 is pretty straightforward. You'll get another agenda that has the next sections that we'll take up with these questions. You can think about them in advance. If you'd like, share your responses in advance. That's all that I have for today. Krista, housekeeping matters, next meetings, anything?
I think we've got our next meeting dates scheduled, and hopefully you all have the calendar invites from Sandy. So I think we're good to go.
And we're using the same Zoom link. Thank you. That's helpful. All right. If that's all that everyone has, thank you for your thoughts ahead of this meeting and at this meeting. I think we are headed in the right direction, especially on these important questions of how do we just move these cases from one court to the other in the easiest way for everyone. So thank you, and we will see you at the next meeting.